This chapter talks about what we call Inchoate offenses. These are offenses that are not completed, so they include attempts, conspiracies, and solicitation. So inchoate means to begin in Latin, okay, and so that means that in these types of offenses, they share two elements. So the mens rea of inchoate offenses has specific intent to commit the completed crime, and the actus reus is some steps towards accomplishing the crime, but not enough to complete the actual offense. So we looked at the general part of the criminal law to find the provisions that govern inchoate offenses. The dilemma in these cases is that no harm has been done yet. So a person is determined to commit a crime but has not done so yet. So the way we resolve this is we require specific intent or purpose to commit the crime or cause a harm. We require some action towards carrying out that purpose, and then we punish these offenses less severely than we would punish someone who had actually successfully completed the offense. So let's look at attempts. Modern attempt law starts in the 1500s, and it develops as people are frustrated with excessive leniency and a very violent society. So the royal court, which is a special court of the monarch, was not bound by common law, and they started punishing a wide range of offenses. But their intent here was to nip violence in the bud. So typical cases involve lying in wait, threats, challenges, and words that tended to challenge. By 1600, common law courts began to develop doctrine of attempt law, and by the 1700s, common law courts had created the law of attempt. So in the case Rex v. Schofield, a servant had put a lit candle in his master's house, intending to burn it down, but the house didn't burn. The servant was punished anyway. The concept here was the intent may make an act innocent in itself criminal, nor is the completion of an act criminal in itself necessary to constitute criminality. And by the 1800s, all attempts are well defined. The rationale here is that we focus on two things. One is dangerous acts. We want to look at how closely a defendant came to actually completing the offense. And then focusing on dangerous persons looks at how fully defendants have developed their criminal purpose, right? So in these cases, we're looking at neutralizing the dangerous person. Attempt law has two main elements, the intent or purpose to carry out a specific crime and the act to actually carry it out, or acts to carry out the intent. There are two types of attempt statutes, general and specific. In the general attempt statute, person is guilty of attempt if, with the intent to commit the crime, he does an overt act toward the offense. Specific attempt, define the attempt in terms of specific crimes, so attempted murder, attempted robbery, etc. Attempt is a crime with purpose, so the mens rea for attempts does not include degree. All attempt crimes require the purpose of engaging in criminal conduct. So there cannot be an attempt without a specific intent. So imagine you're sitting in your apartment, planning in detail when, how, and where you're going to kill your boyfriend and your best friend because your boyfriend cheated on you with your best friend. You decide you're going to do it tonight with your roommate's gun. You get up, you go to the room, get the gun, pick up your car keys, you go to your car. Then all of a sudden you're like, whoa, what is wrong with me? What am I doing? You go back, you turn on the TV. Have you committed attempted murder, and why or why not? Okay, so this is a great scenario that allows us to really think about what does the law require and help us kind of figure that out. Justice Holmes has said there is no law against a man's intending to commit a murder the day after tomorrow. And if you look at that previous example, we don't have anything more than bare intention. Preparing to carry out your intention to commit a crime is not attempt actus reus. What if, though, you went to your room, took the gun, loaded it, got your car keys, got in your car, drove to your boyfriend's apartment. He answers the door, you take out the gun, you pull the trigger, but you miss. Is this an attempted murder? And yes, it is, right? We don't want to let somebody escape criminal liability just because they weren't talented enough or skilled enough to actually complete the offense, right? In this case, you did everything you could to kill your boyfriend, you just missed. So that act represents the strictest rule of attempt actus reus. This is what we call the last proximate act rule. You brought your act as close as possible to committing the crime, right? If you had gone any further, you would have committed the actual murder. So we sort of have a continuum, right, of what is required to commit an attempt. So on one end, we have this last act necessary, and on the other end, anything above mere preparation. In real life, most cases are not that clear. They fall somewhere on the continuum. So the toughest question posed in court is, how close to completing the crime is close enough to satisfy that requirement? So we have two tests, and they reflect two theories. One looks at that dangerous behavior, and one looks at dangerous people. So dangerous conduct tests look at what remains for the offender to do before they actually complete the crime. And dangerous people looks at what have you already done to demonstrate that you are a danger to society. And that includes crimes that a person may commit in the future. Jurisdictions vary as to what constitutes actus reus. So you would want to actually, if you wanted to look at this very specifically, you'd want to look at the actual statute. Proximity tests focus on dangerous conduct, so they're focusing on behavior, not dangerous people. Are your acts close enough to count as a criminal act? Dangerous proximity to success test. Did the actor come dangerously close to committing the crime? So focuses on what they would still have to do to actually accomplish it. So in People v. Rizzo, Rizzo drives around looking for a bank messenger to rob, but does not find one. And the courts have held that this is not close enough. The indispensable element test, has the person gotten everything they need to complete the crime? So a drug dealer cannot attempt to sell ecstasy until they actually have it. Once they possess the ecstasy, they've gotten close enough to satisfy the attempt criminal act requirement. Dangerous persons test. The unequivocality test, Reus ipso loquitur, says the act speaks for itself. Would an ordinary person who saw this person's behavior, without knowing their intent, believe they intended to commit the crime? The probable desistance test, have the defendants gone far enough toward completing the crime? If it is unlikely they will turn back, or the defendants have gone far enough that it's not likely they will stop. And the substantial steps test. And this is in the Model Penal Code. The actus reus of attempt under a Model Penal Code has two elements: substantial steps towards completing the crime, and steps that strongly corroborate the actor's criminal purpose. And this is the topic of this week's discussion board: substantial steps. So these include lying in wait, enticing or seeking to entice your victim to go to the place that you are going to commit the crime, reconnoitering, which means casing, unlawful entry of a vehicle or structure where you will commit the crime, possession of materials to be employed in the commission of the crime, possession, collection, fabrication of materials that you will use in committing the crime, and they're near the place where you have contemplated committing the crime, soliciting an innocent agent to engage in conduct constituting an element of the crime. So enticement, the Model Penal Code, just to clarify a few definitions, MPC borrows from the Indecent Liberty Statute. They say that enticement demonstrates an intent to commit a crime. Reconnoitering, Scouting a scene of a crime indicates the intent to commit it. An unlawful entry is particularly useful for two types of cases. When someone has entered someone's home to commit a sex offense, or when they've entered to steal. So in Bradley v. Ware, two defendants enter a car intending to steal it, but they get out when the owner comes back. The court said this was not an attempt, but under the model penal code, this would be an attempt. Preparing isn't a criminal attempt. Many states have laws that address some activity that constitutes preparation. So Massachusetts has a law against possession of burglary tools, illegal drugs, drug paraphernalia. Now these behaviors could qualify as an attempt if they strongly corroborate a purpose to commit a crime. The reason for this is people who carry weapons and burglary tools with them with the clear intent to commit crimes are dangerous enough to punish them. However, the items have to plainly be instruments of crime. Some states have created preparation offenses, and they're usually less serious. Now, impossibility is a defense to an attempt. So if you were charged with an attempt crime, it's possible you could use impossibility as a defense. We have legal and factual impossibility. Factual impossibility is not a valid defense. These are where actors intend to commit a crime and they try to commit a crime, but some outside factor interrupts them. Okay, so in these cases, you would need different facts to complete the crime. But legal impossibility is a valid defense. Okay, and this is where someone is essentially committing a crime that isn't actually a crime. So an actor intends to commit a crime, they do everything they can to carry it out, but the law doesn't ban what they did. So what about people who start preparing, they take steps towards committing a crime, and then they change their minds, and they voluntarily abandon their plan? This is an affirmative defense, right? So the defendant, you guys recall, for a affirmative defense, the defendant has to produce, they bear that burden of production, right? So they have to produce some evidence that shows they abandoned the crime, and then the government has to prove that they didn't abandon their intent to commit the crime. Abandonment must be complete and has to result from a change in the actor's purpose, not outside influences. So if something intervenes in your ability to commit the crime, that's not an abandonment. The rationale behind this is people who renounce a criminal attempt in progress aren't the dangerous people we want to punish. And renunciation prevents what we most want to prevent, right? Harming someone else. All right, conspiracy laws. We talked a little bit about conspiracy in Chapter 7. Conspiracy is agreeing with one or more people to commit a crime. There is one exception to this. Crimes that require two people in order to commit them don't constitute a conspiracy. As I mentioned before, conspiracy is sometimes a tool used by the government because we can attach legal responsibility for this a lot sooner, and it's often easier to prosecute. And we have some justifications for this. It's designed to stop criminal purpose before it begins, right? Or not before it begins, but it's designed to sort of stop it earlier in the process, and it strikes at the danger of group activity. There are two parts of a conspiracy, actus reus, the agreement to commit the crime, and then some overt act and furtherance of that agreement. Some overt act that attempts to carry out that agreement. Agreement doesn't have to be in writing. You don't actually have to utter the words, we have an agreement, right? There just has to be a meeting of the minds. So Dr. Spock was tried for a conspiracy to avoid the draft law. During a speech, he urged young men to resist the draft. Spectators clapped, and the prosecutor argued that everyone clapping was a co-conspirator. Right? Let's think about this for a minute. Is that really conspiracy? We need an overt act, right? Half states require an overt act in furtherance of the conspiracy, and half of the states require only the agreement to constitute an actus reus. So let's have a little extra credit. Okay, this will be due by Wednesday, March 19th. by 11 a.m. by email. And so since we know that not all the states require an overt act, let's figure out, does Mass require an overt act in furtherance of conspiracy? All right, so what's the mens rea for conspiracy? It wasn't clear at common law, and it's still not very clear. Courts often have been imprecise in determining what they consider to constitute mens rea. Is it specific intent to commit a criminal act, specific intent to commit a specific criminal act? And let's think about, why does this matter? Two men agree to burn down a building, so they've agreed to arson. They didn't intend to hurt anybody, but somebody dies. Have they conspired to commit arson? Do all those in agreement need to agree to each other's purposes? So at what point do people who supply things become co-conspirators? Most courts are held that they need, to be a co-conspirator in those cases, they need to agree to the criminal purpose, and that can be inferred from the quantity of the sales, the ongoing relationship, the seller's initiative, failure to keep records, etc. Parties to a conspiracy, as I mentioned earlier, two or more must agree to complete the crime, and this is what we consider an attendant circumstance. That's the traditional approach. A unilateral approach is that there is no requirement that parties know all the co-conspirators, and no requirement that the state prove the intent of all the parties. It's sufficient to prove that X intended to enter an agreement with Y to commit a crime. Even if Y doesn't really need to go through with it. So if party Y is actually an undercover officer, it's still a conspiracy. You also do not need to convict both parties, so you could fail to convict one party in the conspiracy and still successfully convict the second party. Large-scale conspiracies have two general patterns. We have this wheel and chain. A wheel conspiracy has one or more defendants participating in every transaction, whereas others only participate in one. So Ed conspires with Sam to illegally sell his motorhome. Ed conspires with Fred to illegally sell his motorhome. Ed is the hub, and Sam and Fred are spokes. Sam and Fred don't have to know each other or come to an agreement with each other. They're still considered co-conspirators. Chain conspiracy, everyone handles the same commodity at a different point. If you think about drug networks, these are a pretty good example of a chain conspiracy. The participants don't necessarily know each other. You might only know the participants on either end of your involvement. So in U.S. v. Bruno, we had some drug smugglers bringing drugs into New York. Middleman purchased them, and two groups of sellers bought them from the middlemen. So conspiracy is an agreement to do what? Commit any crime, commit a felony, do something unlawful. So the scope of the objective may vary from being very narrow to being broad. And one of the concerns with this is it can lead prosecutors to really abuse their authority. Some criticisms here also talk about, are we punishing behavior that is too far removed from actually committing a crime? And as I mentioned before, when prosecutors don't have enough to convict somebody on the underlying offense, they will often charge somebody with conspiracy. And so this is quite common in drug offenses. Some states have narrowed the conspiracy elements. And the Model Penal Code has adopted the overt act requirement, plus the requirement that the mens rea is purposeful conduct. So they have argued the Model Penal Code thinks that knowledge, recklessness, and negligence are too far away from conspiracy. So remember, conspiracy is already not the actual crime, and then if we were to allow the mens rea to be reckless or negligent, we're getting even further away. So let's talk about the RICO law, Racketeer Influence Corrupt Organization Act. Okay, we use this to prosecute organized crime. And RICO shows that we still need conspiracy law. So what happens with the RICO Act is there has to be a commission of a predicate offense, okay, and then additional offenses after that. So racketeering is any act chargeable under state and federal law, so it's any crime, murder, kidnapping, bribery, etc. And what RICO does is RICO prohibits you, once you've committed that underlying act, the predicate offense, you cannot use income derived from racketeering to buy into a legitimate business. So the idea here being, if you have engaged in gambling, theft, extortion, and then you want to invest that money in a legal business, the government can come in and then later on seize those assets. So they could seize the so-called legal business that you purchased. All right, and our last Inchoate offense is solicitation. So this is where we basically solicit someone to commit an offense. So maybe I want to murder my wife or my boyfriend or my husband, but I'm afraid to do it. So if I ask somebody, my friend, hey, you want to, kill this person for me, and she does, we're both murderers. If she tries to kill her and fails because her gun isn't loaded, we've committed attempted murder. If she agrees to kill her and buys the gun but doesn't follow through, we've committed conspiracy to commit murder. So hopefully that sort of shows you guys the difference between those offenses. But what if I try to get her to kill my friend or my wife or my husband by offering her $5,000 and she turns me down? Okay, so I go to somebody and I solicit them to murder somebody for me and they refuse. Is that a crime? And yes, for me it's a crime. Solicitation of murder is also a crime. So solicitation is trying to get someone else to commit a crime. Some argue that this is not dangerous enough, that those people are not dangerous enough because they need someone else to commit the crime, and others argue this is dangerous enough. So it's just a bit more removed than conspiracy. The Actus Reus here are statements made to induce somebody to commit the crime. Language in the law might say advises, commands, counsels, encourages, entices. An inducement that doesn't reach its object may also qualify. So if I send a letter to somebody I would like to solicit, that I would like to commit a crime, and I offer them $30,000 to kill my enemy, but the letter never reaches her, I have still technically solicited that offense. The mens rea here is specific intent, and it's a purpose to commit a specific crime. So some states have limited their solicitation laws to soliciting felonies or violent felonies. And that ends this lecture.